All right, hi again. Welcome back. Attorney Steve Vondran here. All right, some breaking news here. This is a new case, and I call this under the heading of social media and First Amendment law. This is a new case that was filed on July 9th, 2019, as you can see up here at the top. Here's the case number, the citation, if you're interested. Now, this case follows on the heels of the Donald Trump case where Donald Trump blocked a Twitter user. And the Twitter user said, what the heck? This is like a public forum. Trump is out there doing his politics and doing all this official government business on his Twitter account. That's a traditional public forum where people are entitled to free speech. You can't just go block somebody because they say something that's negative to you. So that case ended up against Donald Trump, and he was, of course, forced to reinstate the user and allow them to opine on his Twitter channel at Real Donald Trump. So now we have a lot of people following on the heels of this. This is one case. This is with Alexandria Ocasio-Cortez, what some people call, I should say, AOC. AOC. So this case was filed in the United States District Court, Eastern District of New York. Plaintiff I can't pronounce that, Dov Hikind, I probably butchered that, but Dov filed this. He was commenting on AOC's Twitter account. Now, she has two Twitter accounts, apparently, one of her own, her personal account, which has 4.7 million followers, which is quite a few. I think Trump has about 60 million in comparison. But she has about 4.7 million on her personal account, and she also has a government account. But the issue is she uses her personal account for essentially government work. There's a lot of talk here. But let's take a look at this. Again, this is in the Eastern District of New York. This is federal court. This is a free speech case. It's constitutional law. And let's just take a look at this. Now, everybody knows Attorney Steve doesn't get into politics. He just likes to talk about the social media aspects and the legal aspects. And that's what we're doing here. So I'm not going to get into who's who, what's what, and all that stuff. So don't post those comments. I don't like to start fights on my YouTube channel. I like to educate. That's what we do here. All right. So the plaintiff here is known as a staunch advocate for Jewish causes and the state of Israel. Mr. Hikind is the founder of Americas Against Anti-Semitism. Importantly, Mr. Hikind has criticized defendant AOC, I'm just going to call her AOC for short, via Twitter on multiple occasions, most recently in response to AOC's claim that the United States government is running concentration camps on the border, similar to those in the Holocaust. So Mr. Hikind has been blocked by the defendant from the AOC account because of opinions that he expressed regarding AOC and in reply to defendant's tweets. Because of the criticism, Mr. Hikind has been prevented or impeded from viewing AOC's tweets, from replying to the tweets, from viewing tweet discussions associated with the tweets, and from participating in those discussions. So he's blocked and locked out, and he can't engage in the marketplace of ideas, as we like to call it. Number 4, AOC is a popular elected member of the United States House of Representatives. AOC maintains an active Twitter account with the handle @AOC. This is AOC's verified Twitter account and is the account to which AOC regularly posts and engages in both news, events, political speech, and advocates for her positions. AOC uses Twitter as an important public forum for speech. Now remember, these are allegations. This is not fact. Some people get confused. They say, well, if somebody's making the allegations, that's fact. It's not fact. It's just the allegations that are being made. Just bear that in mind as we go here. Number 5, and in an effort to suppress contrary views, defendant has excluded Twitter users who have criticized AOC and her positions as a congresswoman via blocking. This practice is unconstitutional and must end. So there it is, unconstitutional, First Amendment, baby. Number 6, the very practice has been litigated with regard to President Donald Trump blocking individuals on Twitter and has recently been found unconstitutional. So sounds like if you're a public official and you got a Twitter, Facebook, YouTube, LinkedIn account, whatever you might have, People get, and you're using that for business, that's, people get a comment whether you like it or not. So that's, I think, what the law that's going to be evolving out of this case. Just my 2 cents. Number 7, the Supreme Court has acknowledged that social media is a vast democratic forum analogous to traditional public forums such as parks. As the Second Circuit Court of Appeals recognized today, July 9th, 2019, it is unconstitutional for a political figure to engage in viewpoint discrimination by utilizing Twitter's blocking function to limit certain users' access to a social media account, which is otherwise open to the public at large, because they disagree with their speech. Okay, so here's the Trump case, as I told you. This was decided very recently, as you can see. Knight First Amendment Institute versus Donald Trump. We've talked about that on other blogs. Why? Because I love the First Amendment as a topic. It's a great topic. Twitter is an interactive space which is a designated public forum. Okay, so these are treated as almost like a digital park, if you will. It's like a park in cyberspace, but people are allowed to comment there. Okay. 8, the manner in which AOC uses the @AOC Twitter account makes it a public forum under the First Amendment. Defendant's account is open and accessible to all, taking advantage of Twitter's interactive platform to directly engage AOC's 4.7 million followers. Quite a few followers, in case you didn't know, that's quite a few. AOC's tweets routinely generate comments both on Twitter and in the general media. So those tweets can end up on TV is what they're trying to say. 9, AOC uses Twitter to make formal announcements, opine on a range of social matters, both domestic and abroad, endorse candidates, engage with followers of her account, promote defendants' agenda, and other matters. So again, she's a congresswoman, and she's talking about formal business online. So 10, AOC uses AOC far more than her other Twitter handle of @RepAOC, which looks like a House of Representatives type of Twitter account, which probably is not as attractive as the AOC because it's easier to remember and so forth. Defendant's use of @AOC is often multiple times a day with millions of followers. AOC's rep account has only 171,000 followers with irregular postings. So she spends most of her time on her own account, and that's really interesting. Defendant's @AOC handle on Twitter is her primary public forum on that platform. AOC's actions violate the First Amendment rights of Mr. Hyken. Others like Mr. Hyken and those who follow @AOC account are now deprived of their right to read the speech of dissenters who have been blocked. So again, the marketplace of ideas is not being allowed to prevail. 12, plaintiff. What does plaintiff want? Plaintiff respectfully asks this court to declare that the viewpoint-based exclusion occurring here violates the First Amendment, order the defendant to restore Mr. Hyken's access, and bar defendant from blocking access to her Twitter account. So he wants to get in and participate in the marketplace of ideas and give his 2 cents. If you don't like it, just say, I don't like it. If you support it, support it. It's the free speech. It's the open marketplace of ideas. So let's go down and see if we can take a peek at these tweets. I'm not going to bore you with all this legal jargon. So here is her personal account, Alexandria Ocasio-Cortez, AOC. And she puts here in her description area, Congresswoman for New York 14, the Bronx and Queens. In a modern, moral, and wealthy society, no American should be too poor to live. 100%. 100% people funded, no lobbyist. So she's got a lot of followers. Let's go down. Let's see what else we can find here. There's some information here about what blocking is. I think you guys can figure that out. And here it is. Here's the proof that he was blocked. The plaintiff was blocked. AOC blocked you. You are blocked from following AOC and viewing AOC's tweets, which consequently means you're blocked from free speaking and speaking out on the issues. So there it is. That's the official statement. Obviously, she did not want to hear whatever it was he had to say. And let's just go down to the remedies. Let's see. You guys got all that. It's a pretty basic story, right? Let's just go down here to, there it is. The first cause of action, violation of the First Amendment of the United States Constitution, seeking declaratory and injunctive relief. Now, injunctive relief can be both I want to prohibit something and also to mandate something, what they call a mandatory injunction. So here you go. There's the allegations. You can see it there if you want to read it. It's pretty simple. And then coming down here, the prayer for relief. This is an old-fashioned way to say, this is what I'm looking for, Judge. Can you help me? I'm looking at number C, an award of plaintiff costs and including a reasonable attorney fees. Some people would say, why would somebody be motivated to bring this kind of lawsuit? I mean, isn't that expensive just to be able to tweet on somebody's page? Well, there is an attorney fees clause with the First Amendment. And here's one of them, 28 U.S.C. section 2412. And what that section deals with is the court may award attorney fees. Not mandatory. The court may award attorney fees for good, just causes. And this is where it's involving public officials. So this is a case. We'll keep an eye on it for you, and we'll give you a little notice of where it goes. Huckine versus AOC, United States District Court, Eastern District of New York. So this is one to watch, but I think what we're going to see is a precedent being set that when you're paid by the government, you're paid by the taxpayers, that when you're engaging online social media accounts in official business, that you're not going to be in such a great position to block people is the best thing that I can put. Now, there may be some circumstances where it is proper. I don't know. We don't know that yet, but we're going to keep an eye on this. So I hope you like this. If you need help with civil litigation, First Amendment, social media issue, intellectual property, you know where to find me on the web at attorneysteve.com, the first name in legal services. I'll let you go. Enjoy your meal. I thank you for watching. If you enjoyed this video, give me a thumbs up. If you say, I want some more political videos, Attorney Steve, without the political nonsense, let me know. Give me some comments in the comment section below. And don't be afraid to subscribe to broaden your horizons. Attorney Steve out. I got to run. My dinner's on the table. Have a great evening.